Our top story. We often say India's bureaucracy moves in slow motion. No such problem today. The Lok Sabha Speaker has disqualified Rahul Gandhi from his parliament membership in record time. He was convicted of criminal defamation yesterday. He lost his parliament seat today. Now, as things stand, Rahul Gandhi is not an MP anymore. He has lost his seat from the Wayanad constituency in Kerala. It's now up to the Election Commission to decide when they want to announce a by-poll. Sources are telling us that the Election Commission plans to wait and watch. But looking at the speed at which things are going, who knows? It could be called tomorrow. Rahul Gandhi himself has reacted to his disqualification. He has tweeted saying, and we'll put that out for you as well on our screens, he says, "I'm fighting for India's voice. I'm willing to pay any price for it." That has been his first and only reaction today. In many ways, we can say we saw this coming, so did the Congress party. Once the Surat court convicted Rahul Gandhi of criminal defamation, the BJP immediately started talking about his disqualification. Meenakshi Lekhi was on record saying it yesterday. And technically, they were going by the rule book. The law says if any MP is convicted and given a prison sentence of 2 or more years, they can be disqualified immediately. It has happened to a long list of leaders before Rahul Gandhi. The Lok Sabha Speaker is not required to wait for the legal appeals to play out. Having said that, the Congress says this decision reeks of political vendetta and overreaction. Now, not for a moment am I defending what Rahul Gandhi said way back in 2019. It was immature, it was unnecessary, it was irresponsible, and he should have thought about the consequences. But is the reaction greater than the action? Was Rahul's offense so big that he had to be disqualified within 24 hours? I think we all know the answer to that. The BJP, of course, is calling this the law of the land. They say Rahul Gandhi should have kept his tongue in check or apologized for his comments. But the opposition is up in arms. As we speak, the Congress has concluded a special strategy meeting to chart out their next course of action. Their top leaders are accusing the government of murdering democracy and trying to silence Rahul Gandhi. Even his rivals like Arvind Kejriwal and Mamata Banerjee are defending him today. All of them say the Lok Sabha Speaker's actions were excessive. Now, let's be clear about one thing. We are not questioning the wisdom of the court that convicted Rahul Gandhi. That's a separate issue. We are questioning the speed, the scale, and the severity of the decision taken by the Lok Sabha Speaker. Stripping an MP off his Lok Sabha seat is no small matter. It is a decision that should be taken with neutrality and political maturity. Was it? That is something I'm putting to India's most distinguished legal eagle, Mr. Mukul Rohatgi, who is joining us on the broadcast. He's also been a former Attorney General. Mr. Rohatgi, first of all, thank you very much for your time here on Mirror Now. Mr. Rohatgi, a lot has been said about Rahul Gandhi's sentencing and his disqualification. Can you help our viewers understand how a rhetorical speech made from a political stage has ended up suspending an MP for 6 years? I mean, politicians say the darnest things all the time. By that yardstick, 30% of our MPs would have to be suspended.
On the first question, I've heard you for the last 5 minutes, and people seem to think that the action of the Secretary General of Lok Sabha was rather prompt and very fast and all that, and therefore they should have waited and all that. Let me make one thing very clear. The law does not require the Secretary General to issue any order at all. The moment a conviction is recorded by a court, disqualification takes effect automatically the next second, not even the next minute. So it was not necessary for the Lok Sabha to issue any order. Whether they did it today, tomorrow, day after, it is of no consequence, because the disqualification has attached itself to the membership of Mr. Rahul Gandhi. That's the first step. Let's be clear. Do not accuse the Secretary General or any other office in Lok Sabha because that was wholly unnecessary. Now that is the law. You can say that the law is unreasonable, but the facts show that when some respite was to be given from such an immediate disqualification, Mr. Gandhi himself tore up the amendment which was sought 10 years ago. So, well, then that's the law. It applies to everybody. Now, let's look at the question you asked. Well, my answer is this, that this is the law. This has been the law from 1860 as to what is defamation. And the law of disqualification has been there for years and years. Everybody knows the law, and more so the politicians. And if you ask me, I have been watching, and you have been watching, and the public has been watching, the new law which has reached in all the legislative assemblies and parliament and municipal corporations as to how the law makers are behaving. They're throwing things at each other. They're calling each other names of the worst kind. I mean, you call yourself a mature democracy or the largest democracy. Yes, largest it is, but it doesn't seem to be that mature the way things are going. And people are taking, as if it's all free for all. There is a law of the jungle. Everybody has the right to say anything. But please remember, as far back as 1860, the law was made that, if you demolish somebody's reputation or character, which jolly well takes more than half a lifetime to build in a space of a few seconds, because what you say is carried across the internet to millions of users, millions of listeners on social media. So the most important thing is, the more the responsibility, the more the introspection. Now, here is a person who is in charge of a big political party, whose utterings and whose voice is heard across the nation and across the world. When you make such scandalous allegations which have no basis, there is no doubt as to what the accused meant, Mr. Gandhi meant. He meant to attack the Prime Minister, who had nothing to do with the two other persons that he named, Nirav Modi and that Lalit Modi, except that they shared a common surname. I mean, there are 10 crore people who share a surname called Modi. There may be 10 crore Sharma, there may be 5 crore Kapoors, there may be 2 crore Sethis, whatever. But here the allegation was made by a high political functionary against a high political functionary, which was a completely, below the belt, by saying, well, you are a Modi, they are Modis, are all Modi's chores. I mean, there's no doubt about it. So I want to end by saying, this should be a beacon judgment. Everybody should look at it and and feel that if we are going to say all this, this might happen to us. I think it's a judgment which is required in the current laws that we are facing.
Mr. Rohatgi, the sentence is by the book, the suspension is by the law. I understand that no rules were broken, no laws were broken. But there is the law, and then there is the spirit of the law. As a seasoned legal luminary, do you think the punishment by the Surat court and the haste with which Mr. Gandhi was suspended by the speaker was appropriate? If the Surat court has given Rahul Gandhi 1 month's time to appeal, where was the need to rush to suspend him, sir?
Sorry. I again tell you, Shreya, the effect of the Secretary General's letter is nothing, is zero. It has no meaning. You can throw it away. The suspension or the disqualification applied the moment the judge passed the judgment. This is what I've been trying to say on TV for the last 4 hours on different channels. You do not require what was done by the So that's the law. It happens. There are some laws in contradistinction, which say that this will take effect if such and such person passes an order or is authenticated by the governor or a gazette notification is issued. Then, it takes effect. There are laws of that type also. But here the law is, it takes effect automatically. If it does, it does. What can be done about it? Either change the law. Don't blame the parliament or the
Understand that.
secretariat.
I understand that. I understand that, but let me ask you again a question on the hastiness, and I ask you this question in the backdrop of what has happened with Lakshadweep's MP Mohammad Faisal. He's sentenced to 10 years in prison for attempt to murder. He's disqualified immediately. It's as per law. The EC then
Yes,
orders a bypoll as per law, and then the
yes.
Kerala High Court stays its sentencing, and the Supreme Court cancels the bypoll. So he's back to being an MP. Of course, a different matter that the
Correct.
Lok
So,
Sabha
so
Secretariat
very
is not
simply,
allowing him to enter.
so no, Shreya, very, very simply, we do it every day. This is not the first time this has happened. Every day this is done. The least that was required of Mr. Gandhi with a vast, material and talent of legal minds with them, all they required was they should have filed an appeal yesterday to be taken up at 4 o'clock before the appellate court. They should have requested for a stay, or should have done it today. They can do it tomorrow. The election commission is not going to act in the next 10-15 days because it takes time for them to assess the situation and then issue a notification and then actually conduct an election. In the case of the other MP, he was sentenced to 10 years. Not easy to get a stay of that nature. He was lucky to get that stay. Now, here, it may be a better chance for Mr. Gandhi to take a stay, but then he should apply for a stay. He hasn't applied for a stay. What are they waiting for? And
Okay.
mind you, it's very important to know that a stay which is required for him to re-enter parliament is a stay of the conviction. That is, stay of the finding of guilt and not
Correct.
merely a stay of 2 years. That's very important. But then what are they waiting for? You should do it. If they get a stay, things are hunky-dory. If they don't, they don't. And every day, I have done hundreds of cases where people are disqualified from different houses on account of different problems like corrupt practice, this, that, so many things. We go to the Supreme Court. Many times you do not get a stay of conviction. You get what is called a partial stay, which in lawyers' language is called the Indira Gandhi stay.
Okay.
The kind of stay Indira Gandhi got in 1975. That was a stay which said that she can go into parliament, she can take part, but she can't vote. Things like that. All that is a matter which will happen later. But then don't blame. If you blame the law, then you should challenge the law. Law is not under challenge. Second, if you want to stay, you better jolly well.
On that note,
Oh.
On that note, can I ask you this, Mr. Rohatgi? Is it time for us to start debating whether we should decriminalize the defamation law? I mean, there are countries in this world that have decriminalized it. Why should it be a criminal case in the first place? Why not a civil case? Has the time come?
I expected this question from you, so I did some homework. I found on Google that about 120 countries in this world, including developed countries far and wide, still have criminal defamation, including the US. Now, we are a large democracy, but I don't think we are the maturest democracy. If those democracies have it, and the way we have seen how lawmakers are behaving in these august houses, I don't think it is appropriate to do away with it for two reasons. One, it takes only 5 seconds to destroy somebody's character and besmirch his reputation on social media. It takes only 5 seconds. And it takes 50 years to build a reputation. That's number one. Number two, civil defamation and our legals, and I'm prefacing it by saying that our legal system is very slow. If you file a civil defamation recovery of damages, courts do not give any importance or priority to such cases. There are crores of such cases, cases of all kinds. So if it's going to take 20 years or 50 years for a civil defamation to decide, you might as well forget it. Therefore, with these two aspects, the maturity, the way things are happening, the present scenario, and the way our legal system is, I think it is imperative that this should be retained. It was challenged, if you remember, by Mr. Subramanian Swamy about 10 years ago. On the grounds that you were saying freedom of speech, this, that, and the other, it was not accepted by the court. And I don't think the time has come today, at the moment, to do away with it, unless we put other, things in place.
Mr. Rohatgi, such a pleasure speaking to you. Thank you very much for joining us here on Mirror Now. Good to have you on the show.